Imagine you are the main contractor against whom the employer has sought to impose liquidated damages for delay. However, part of the delay was caused by the subcontractor nominated by the same employer, NSC. You therefore would like the arbitration between the employer and yourself to be heard together with your arbitration with the NSC. Question is, can this be done? Introducing the case of Bumi Metro Construction v. Glomac Al-Batar Mutiara, 2025, High Court. Bumi Metro was the main contractor for Glomac for a project in Mutiara Damansara. The lift services were provided by ITA Elevator, and NSC. Glomac claimed against Bumi Metro for liquidated damages and rectification costs of over Rm 16 million. ITA has also claimed against Bumi Metro for unpaid sums. Bumi Metro asserts that some of the delay and defects were caused by ITA, so it wanted the two arbitrations to be heard together. Both ITA and the arbitrator refused. Bumi Metro then applied to court for essentially the same order. By law, courts exercise minimal intervention into arbitration proceedings. The learned judge in this case held that there was no provision in the Arbitration Act which allowed for the judge to order a consolidation. Consolidation can only take place under Section 40 of the Arbitration Act if parties agree. Even the arbitrator cannot make such an order. The PAM form has a provision for parties to use their best endeavors to ensure employer-contractor NSC arbitrations are heard by the same arbitrator, but it is rarely enforced or agreed to. In short, there is a tremendous difficulty to procure a consolidated arbitration proceedings. Instead, a main contractor may have to commence arbitration proceedings against the employer and the NSC at approximately the same time, in order to manage the timing and progress of the proceedings accordingly.